Hi friends, my name is Alina Shaltsova. I'm an immigration attorney from New York. Today's video is going to be about asylum and different procedures that are used in the United States to request asylum. We will be discussing the two different procedures that you can be subjected to if you're asking for asylum in the United States. I'm referring to defensive and affirmative asylum process. The first thing that you need to know is that you will not be able to choose which procedure is going to be used. The law chooses procedure for you. Defensive asylum process will happen if you are in EOIR or Executive Office of Immigration Review System. And affirmative asylum is going to happen if you're with USCIS. Sometimes it is confusing to understand which system you are under. Technically, until the notice to appear is filed with immigration courts, USCIS should have jurisdiction over you. But because of the recent changes as to how migrants are processed at the border, USCIS and EOIR developed their own little procedure how to deal with people who were issued notices to appear, but those notices were not filed in court. Basically, the common understanding is that those people will go through EOIR system, but while they're waiting for their notice to appear to be filed with immigration court, they can use USCIS as well. Times, however, you will not be confused like that. Most of the times it will be pretty much clear as to what you need to do and when. So usually if you cross the border, well entered with between the points of entry, or you had a visa, you're going to use affirmative asylum process. It means that you're going to be filing your form I-589 with USCIS. And currently, government allows you to do, for those purposes, electronic filings. I personally not a fan of that, just because it still has glitches, but I'm sure with time, the electronic filing is going to be nothing but pleasure, but not so much currently. But it is available for you, especially if you are more comfortable with electronic means of communications. This will be a good option for you. I prefer paper filing. So affirmative asylum means that you're filing your application just like any other application for any other immigration benefit with USCIS, and then you sit and wait. First, you're going to be waiting for government USCIS to issue receipts confirming that your application was accepted. Then you will be called for the fingerprints, and after that, all you have to do is to wait for your asylum interview. That's it. Of course, you have to prepare for the interview, meaning that you still have to collect your evidence. Maybe you can strengthen your case by finding an expert, begging witnesses to testify and give you letters of support, following up the stories, developments in your country, and so on and so forth. But affirmative asylum process means that at some point you will be called for an interview with USCIS asylum officer. Asylum officers are not judges, and they will make a decision on your case, but if it's a grant, you will receive asylum status. But if it's not a grant, they don't call it a denial. This is a difference. They're calling it a referral usually. They will be calling it a referral if by the time they made their decision, you do not have lawful non-immigrant status in the United States and you're subject to removal. They will be placing you basically in removal proceedings. They will be the ones issuing that notice to appear, placing you in or under immigration court jurisdiction. Your defensive asylum process is going to start. When you are defending yourself from removal, this is, and by filing asylum again or renewing your application again with immigration court, which has authority to review your claim de novo, meaning as new, as if it's never been heard before, you will be going through defensive asylum process. So let's talk about this. What is the difference? You're filing for asylum there and there, USCIS and EOIR. What is the difference? Well, I'm going to go straight to the main point. The main difference in my mind is ability to travel. I cannot tell you that ability to travel or advance parole document is so easy to receive when you're in affirmative asylum procedure, but it's a possibility. Many clients who can show that they have a medical emergency for themselves or their loved ones are able to receive advance parole travel document authorizing them to travel when they're going through affirmative asylum process. But to my knowledge, nobody ever has been able to do that when they're in defensive asylum process. Why? Because there is a direct prohibition on issuance of advance parole documents for those who are in removal proceedings. Of course, there are some other differences during these two different procedures. For example, document preparation difficulty. I would submit to you that it's more difficult to prepare your documents for the court than for USCIS. USCIS is extremely forgiving. They really do not care the way the documents are presented, but the court is very strict about that. In fact, there are cases where persons suffered a denial because they could not either comply with a deadline established by the court or otherwise just couldn't deliver the documents to court. You need to know that generally speaking, the case is going to travel faster through the court system than through USCIS. Well, at least that was the case until recently. Currently, there are 2.5 million cases with immigration court system. Many cases are going to be taken off the calendar and placed into what's trial queue. It means that we do not know when you're going to get that final trial court date. And it may also take years and years. But in the worst case scenario, usually your case is going to be pending in court on average for about 3 years. Currently, some affirmative asylum cases are pending with USCIS for 8 years. So, of course, some people may see this defensive asylum process as a faster mean to resolve their asylum claim and receive that resolution they're seeking for, receive that decision. But remember, it's not always the case, and there are exceptions. Now, the good news that in both procedures, you will be usually entitled to a work permit if your case has been pending for 150 days. A referral to immigration court system does not stop this asylum EAD clock. It's very, very important to know that. So you're going to get the same work permit whether you're in court system or if you are with USCIS usually. Again, there are certain teeny tiny exceptions that may apply. In the affirmative asylum process, if you have dependents with you in the United States, you added them properly to the case. As soon as you receive your grant of asylum, you're going to convey that status automatically to your dependents, and no separate forms will have to be filed for them to enjoy status. I hope this video is helpful for you. So thank you very much for watching, and if you have more questions about differences in two procedures, let me know. Thank you very much, and I hope to see you soon.